All right, I think we may still have some people left to join us, but we'll get started. So welcome those of you who have joined us, and thank you very much for joining us with the IPBA International Trade Law Committee. My name is Tracy Epps. I'm a trade law consultant at Chapman Tripp, a law firm in Wellington, New Zealand, and I'm the current chair of the Trade Committee. We're very grateful for you joining us today. We know there's a lot of Zoom fatigue out there, and webinars are not quite the novelty they once were, but we do appreciate you joining us as it helps us to all stay in touch during this time. Now, before we get started with our program today, I believe we have a short message from our president. So I'll just pause for a moment while that is played.
Dear speakers, distinguished guests and colleagues, I thank IPBA officers for organizing this timely seminar, taking place under the devastating impact brought by COVID-19 pandemic. I do appreciate the joint efforts and collaborations from all members and officers working for IPBA during such a difficult time. The COVID-19 pandemic represents an unprecedented disruption to the global economy and world trade, as production and consumption are scaled back across the globe. However, when we look back into the global trade landscape, the trade war and the subsequent remedies taken by countries still deserve timely updates and study. Anti-dumping action, countervailing duty measures, and safeguard action. These remedies are triggered in response to different situations and circumstances, which may be causing material injury to a domestic industry. Recourse to these tools is initiated by the domestic industry. The following outline the relevant WTO rules and also provides a short summary of the circumstances which give rise to recourse to such remedies and the procedures for activating their use. As governments continue to tackle the ongoing COVID-19 crisis, trade remedies are alive and well. In 2020, G20 members initiated a total of 279 anti-dumping investigations, 54 countervailing duty investigations, and to safeguard investigations. The most frequent initiatives of trade remedy investigations in 2020 included India, the United States, Canada, Australia, and the EU. In this seminar, members of the Inter-Pacific Bar Association International Trade Committee will provide an overview of recent developments in trade remedies in key jurisdictions of interest to our members. Today, we have different jurisdiction speakers representing major world economies to talk about the trade policies and remedies recently. And let us welcome our distinguished speakers for today. Thank you for your attention.
Thank you very much. So as our president has said, both WTO agreements as well as bilateral and regional agreements provide safety valves for domestic industries who suffer injury in the face of trade liberalisation. And our president has mentioned the three trade remedies: anti-dumping, duties which can be imposed at the behest of a domestic industry if they can show that goods are being dumped and causing them material injury. Countervailing duties can be imposed again at the behest of a domestic industry if they can show that another country is subsidising its domestic industry and that's resulting in adverse effects to them. And finally, safeguard measures can be imposed if a domestic industry suffers serious injury due to a sudden and unforeseen increase in imports as a result of tariff concessions. And each of these remedies imposed following a domestic investigation, and of course of great interest to our members across the globe. And so today we have speakers who will give us an update on what's been happening in the trade remedies space over the last year, and what we, and particularly maybe some of the trends that we're seeing that might be in some way related to the current pandemic. So our first speaker is No Song Fong Kim from Page Vera Law Firm in Chicago, who will talk about the United States. Our second speaker will be Augusto Vecchio from Beca Varela in Buenos Aires in Argentina. And then we have TD Satish and Sitharapin, Sampath, both from New Delhi, from NITYA Tax Associates and Savada Legal, respectively. And then we will have Carla Ananda Raja. Apologies, it's getting late in the evening here in New Zealand. My, my pronunciation is failing me, from Raja and Tan in Singapore. And finally, very happy to have someone with us from the European Union as well, as that's obviously a market of great interest to many of our members, Nikolaj Kuplewatsky from the Court of Justice of the EU in Luxembourg. So each of our speakers will have about 10 minutes each. Please do ask questions. We encourage you to use the question function or the chat function to ask your questions, and feel free to do that as we go along. Over to you, No-Song.
Well, thank you very much, Tracy, for the wonderful introduction, and good morning, good afternoon, good evening to you all from wherever you are tuning in. I hope yourself and your families are continuing to stay safe as we begin to recover from COVID-19 pandemic. So the focus of my presentation today will be on US government's recent use of withhold release orders, WROs, to ban the imports of goods that the US government deems to have been a product of forced labor, and to provide some recommendations that about what the importing community could do to sort of mitigate the risk of non-compliance. And I begin with some framing of the issue for context. Now, when we study trade history, the one constant that we would often find is that trade policy and foreign policy have oftentimes intertwined, with foreign policy tailored to promote trade interests. Now, from a US perspective, which is of interest to me, being an American and living in the United States and practicing in the US, for most of the last 80 years or so, trade policy has been the bedrock of US foreign policy, essentially dating back to post-World War II. So I think it's within this framework that we should view the recent imposition of sanctions for transactions that the US government deemed to have used forced labor in their supply chain, or could be used to violate human rights, has been the case with the issuance of WROs. So how did WROs become such a powerful tool for promoting US trade policy interests? The authority to impose sanctions on products produced with forced labor has been really in the books since the Tariff Act of 1930s. And what that law did was it requires the US Customs and Border Protection to stop all goods made in whole or in part with forced labor from entering the commerce of the United States. Initially, this law was designed primarily to protect US business interests from unfair competition of cheap forced labor, but in 2015, the law was amended to remove what they call the consumptive demand clause. And what that consumptive demand clause really did was said, you can import goods into the US that are produced with forced labor so long as there is inadequate supply to meet the consumptive demand of US consumers. So the removal of the consumptive demand clause really strengthens US Customs and Border Protection's ability to target shipments that it suspects are products of labor-related human rights abuses. Now, I should also add that as we speak, two competing legislations are working their way through US Congress right now, titled the UGOR Forced Labor Prevention Act. And if passed into the law, it's going to do two things. First, it might penalize Chinese officials for their alleged involvement in UGOR forced labor practices. And also, secondly, it could effectively ban all goods produced in the Xinjiang region of China, unless the importer can prove that the goods were not produced with forced labor. So in the last 5 years, for example, through the issuance of WROs, CBP has taken actions on tobacco from Malawi, seafood cut on numerous Taiwanese fishing vessels, disposable gloves from Malaysia, which I understand last week that ban was essentially lifted, and on numerous organizations operating in the Xinjiang region of China. So we've been talking about WROs now for the last 5 minutes. What are they really? WROs indicate to the US importing community that if there is a reasonable evidence that forced labor has been used in the production of shipments likely to pass through a US port of entry, and that these goods will be stopped for further evaluation. And typically, WROs are issued following a detailed investigation by CBP. And these investigations are typically triggered by allegations submitted by interested human rights group or labor-related groups, or they are initiated by CBP itself. Once a WRO has been issued, the importer has 90 days to provide evidence that the labor used in their supply chain has been treated fairly. And they can do so by submitting documentations that may include, for example, factory visits, audit reports, supply chain maps, or any other evidence necessary to support their defense. If that evidence is not compelling, then the importer must export their goods out of the United States, or CBP may seize and destroy the particular shipment. And if CBP finds evidence showing that forced labor that meets its probable cause standards, then it may issue a finding in the Customs Bulletin and the Federal Register, which essentially provides for the seizure and destruction of similar goods upon importation into the United States. And it may also issue civil penalties as well. Now, bearing that in mind, what can importers do to mitigate the risk of non-compliance? We often advise most of our clients to remain vigilant and to be able to track and monitor ongoing developments that could impact their business. So from a sourcing perspective, which would be the area that would be most affected by WROs, we would typically advise them to evaluate the entire supply chain to ensure that their products were not produced with forced labor. Or in some instances, we would even advise them to consider shifting their manufacturing and sourcing operations entirely out of regions where the US government deems to be highly sensible to forced labor. Now, I understand that recent targets has been in the Xinjiang region. So obviously, if China is a big market for you, then that's going to be a much more difficult decision for you to make. But so I conclude my short presentation, and I guess I pass it to my next colleague.
Hi, everyone. Sorry, here I am. Good morning, everyone. This is Augusto. Thank you, Tracy, for the introduction, and thank you, Nasong, for your presentation, and also for passing me, the word. And I would like to give thanks to Jeffrey and Rhonda also for inviting me for this webinar. This is very early in Argentina. As Nasong says, good morning or good afternoon or good evening, wherever you are. I will share some presentation and to provide an update of the trade remedies in Argentina. Just a second, please. Let me see. Is it okay? Okay, thank you. Well, as I said, I will provide a short overview of the trade remedies practice in Argentina. In this regard, maybe to put some context, We should point out that the last amendments to the local regulations took place in 2008, and that during the last years, there have been no significant changes in the administrative structure, the government agencies that conduct investigations. During the last 12 years, there has been not, changes in the regulations or in the technical bodies that conduct investigations. So the process is very consolidated in Argentina. There were some developments in 2017 regarding China. Due to the termination of the waiting periods of the Chinese accession protocol to WTO, there were some developments regarding the market status of the Chinese exporters that we will discuss at the end of the presentation. And currently, during this year and 2020, as an exceptional measure to respond to the COVID-19 pandemic, some anti-dumping duties, sorry, excuse me. That we are starting the day in Argentina, so the phone starts ringing with the clients and all the work and that stuff, so sorry. Due to the pandemic, the authorities have decided to, as an exceptional measure, to suspend the application of certain anti-dumping duties that were connected with products that were deemed critical for responding to the COVID-19 pandemic. We are talking about syringes or parenteral solutions or some textiles that are needed for surgery, stuff like that, sanitary products, just to simplify. Now to provide some context about the trade remedies in Argentina, as a party to the GATT agreement, Argentina has regulated the local procedures for conducting investigations and imposing safeguards, countervailing duties, and anti-dumping duties. However, during the last 25 years, Argentina has conducted safeguard investigations only in 7 times. The last one in 2007, so it's not a popular tool for authority here, the use of the safeguard as a mean to protect the local production. These safeguards, were connected with textile products, footwear, and toys. Those were mainly the products that were covered by these safeguard procedures. Talking about subsidies, the number is even lower. We have only 3 precedents during the last 25 years in Argentina. And those precedents were at the beginning of the GATT 1994 new era in 1996. And there were 3 investigations that were connected with gluten, olive oil, and canned peaches, and they were all against the European Union. And now, the most popular or the most common trade remedy measure adopted by the Argentine authority is the anti-dumping duty. Our practice, if you have a private practice of trade remedies in Argentina, you will be focused mainly on anti-dumping investigations. During the last 25 years, the authority conducted almost 450 investigations, and more. These 450 procedures includes also interim and sunset reviews, and more than 230 definitive anti-dumping duties were imposed during the last 25 years. Just to provide a very short explanation of the anti-dumping procedure in Argentina, which is, the main tool or the main measure that the authority will be likely to adopt if the local industry requires some protection due to unfair practices in international trade. This is I don't want to take much of your time with the chart of the authorities, but we have two main technical bodies that are the Directorate of Fair Competition, the DCD, and the National Commission of International Trade, the CNC. Our procedure is divided into two authorities. The DCD analyzes mainly determines the dumping margin, focus on that part of the investigation, and the National Commission of Foreign Trade focuses on the determination of injury or threat of injury and the causality. These two agencies are the technical bodies that are in charge of the investigation. There you have some technical officers that have been there for more than 30 years, so they are very technical agencies, and they issue a recommendation to the Undersecretariat of Policy and Trade Management, who at the same time issues another recommendation to the Secretariat of Industry, who issues a last recommendation to the Ministry of Productive Development, who is the guy that decides on the application of the anti-dumping duty. Well, these are the functions of the technical bodies. I would not take much time here. What we should have in mind is that the DCD is in charge of the dumping margin, and the CNC is in charge of determining the injury and the causality, and the ministry is the one who decides on the application. Talking about some of the figures, let me see. During these last 25 years, and maybe to have an idea of the size of the issue in Argentina, during the last 25 years, Argentina has adopted, as I said before, more than 230 definite anti-dumping duties. Of those definite duties, 62% were adopted at the end of an initial investigation. I mean, I am saying initial investigation just to differentiate it from the reviews, from the interim and the sunset reviews. And the last 40% were implemented after sunset or interim reviews. Of those 144 duties imposed during initial investigations, 63, I mean, more than 40% were extended at least once. There are some popular cases like the sanitary ware from Brazil. Such duty has been extended during the last 15 or almost 20 years. It's a very old duty. Of those 230 definite duties, 105 were adopted in the form of FOB minimum prices. 92 were anti-dumping ad valorem duties. Now, this is the most common mean to adopt an anti-dumping duty. I mean, during the last 5 years, the authority is applying this type of duties. I mean, the ad valorem duties over the FOB value of the imported goods. And we have in 33 times they adopted a specific custom value. Almost 80% of the definite anti-dumping duties were adopted against China, and the other most frequently frequently investigated origins were Brazil, India, South Korea, Taiwan, and certain European Union countries like mainly Germany and Turkey. Sorry. As I said at the beginning, maybe the most significant developments during the last years in the Argentine practice or anti-dumping remedies practice were the developments regarding China. As you know, before 2017, Argentina has consistently denied the market economy status to China. Therefore, for the dumping margin calculations, the authorities used to consider the normal value of third countries, in general prices in Brazil, if like product was manufactured there. Accordingly, using this methodology, anti-dumping margin, determinations were huge. And it was very unlikely that Chinese exporters would participate in an anti-dumping case in Argentina. It was very difficult to get the market economy status, and additionally, the export volumes, I mean, the value of the goods that were annually exported to Argentina, in many cases, didn't worth the efforts and the investment for filing a decent defense. After the waiting periods of the Chinese accession protocol to the WTO were terminated, Argentina did not issue any formal declaration about whether it would recognize the market's economic status to China. Still, our government did not make any formal declaration. At that time, the Argentine strategy consisted in waiting to see the approach of the Western powers, I mean, mainly the US and the European Union, how they would approach this issue. However, in May 2017, Argentina initiated an anti-dumping case against China regarding the exports of sanitary ware. This case is very important because it marked a change in the criteria of the Argentine authorities. Without making any specific declaration, the authorities stated for the first time that for the dumping margin calculation, the Chinese domestic prices were going to be considered for determining the normal value. I mean, there was, as I said, there was no formal declaration. There was just sending the normal market economy status exporter questionnaire to the Chinese exporter and requiring the domestic prices in China in order to determine the normal value. So this was in fact or tacitly granting market economy status to China. Some of the most recent cases in which this approach was taken are the cases of safety gloves, cloth iron, and refrigerant gases, among many others. I mean, from 2017, from to nowadays, the government has been, in fact, or tacitly granting market economic status to the Chinese exporters. However, there is no case still there is no case where the Argentine authority has granted an individual determination to a Chinese exporter. I mean, the exporter questionnaire for the Chinese exporter is rather burdensome because they need to comply with a lot of certifications, auditing, and legalization requirements, and also translations to Spanish that must be carried out that must be done in Argentina. So the process for a Chinese exporter implies a significant, maybe implies an investment, to make an investment, and takes and the waiting periods of the investigations. I mean, you need to comply with all the stuff in 30 days, and maybe you can get an extension for 30 additional days, but maybe in the distances between Argentina and China makes it difficult to comply with all this stuff in 30 or even in 60 days. So sometimes the Chinese exporters do not make it to comply by the applicable deadline, and so they do not get an individual determination. And again, it is very likely that maybe the exporting volumes to Argentina do not worth the effort of the Chinese exporter to comply with all this stuff and to allocate the resources to make it before the deadlines. Only one case, in only one case, the authorities have accepted an undertaking, a price undertaking filed by the Chinese exporter. Is the case of the sanitary ware. I mean, the positive news is that for a Chinese exporter, it is possible to offer a price undertaking. I mean, if they don't make it to get an individual determination because they cannot fulfill all the requirements before the applicable deadlines. They have the possibility of filing or requesting the acceptance of a price undertaking. That's the development of regarding China. And lastly, maybe to provide, I don't know if my time, sorry Tracy, but due to as the phone was ringing, I didn't pay attention to the timing. Maybe I have passed my 10 minutes, but just as a final word, about Latin America, as you may be aware, the main users of this system, I mean, the anti-dumping duty mainly, are Mexico, Brazil, and Argentina, who are the main economies. And currently, and for the last years, not currently, Peru and Colombia is following this trend. Well, again, thank you very much. And sorry for the interruptions of the phone.
All right. Thank you. Thank you, Augusto. Thank you, Nosong, and thank you, Tracy, for attending this webinar today and introducing us to the various concepts. So as Tracy has already introduced the concept of trade remedy measures, we will not delve into it deeply, and rather I, along with Mr. Sitaraman, will focus on India-specific issues relating to trade remedy measures. So we have a presentation that we will take you through. Yeah. So is this visible?
Yes.
All right, thanks. So when it comes to India, generating numbers is not an issue, and same applies in respect of trade remedy measures as well. So if you see the WTO statistics, India ranks #1 when it comes to applying trade remedy anti-dumping measures. Similarly, it is #2 when it comes to applying safeguard measures, and #5 when it comes to applying countervailing duty measures. So with all these investigations taking place and measures getting imposed, number of issues are bound to arise. So which sometimes lead to litigation, which eventually lead to change in either law or in the practice that the authority adopts. So with this, we'll come to recent changes that has taken place in 2020 as well as 2021 as a result of number of investigations that take place. So we have divided this webinar into two parts. One relates to legal updates, where we will cover certain key important updates relating to legal development. And thereafter, we'll also see some practice area developments that have taken place. So jumping right into legislative changes that have taken place. First relates to introduction of draft anti-absorption provisions by India. So while it is there in other jurisdictions already, India has very recently introduced this concept, and draft rules have been proposed. So in this, there are two issues that one has to consider. One relates to the trigger as to when this rules and this anti-absorption provisions can be applied. So as the existing rules say, it can only be started when there is a decrease in export price by the foreign exporter, and there is no commensurate decrease in cost of production, export price to other countries, or resale price in India. So one of the issues now that will arise is that while authority can only examine decrease in export price of the foreign exporter, but there is no provision that requires the authority to examine subsequent resale price when the product is imported into India. So, for example, if a foreign exporter post imposition of anti-dumping duty or countervailing duty does not decrease the export price, but an unrelated importer in India or a trader in India reduces the prices, then what will happen? The present rules does not provide for a solution. Another interesting concept that is there, which has been introduced in the draft provisions, is that the authority can also redetermine the normal value, which is required for recomputing the dumping margin, and non-injurious price, which is required for redetermining the injury margin in India. One does not know in an anti-absorption rules what is the need to redetermine normal value in non-injurious price, but by the looks of it, it appears that the decrease in export price is just a triggering event which will enable the authority in India to initiate a very limited MTR or midterm review to only reassess the dumping margin or injury margin and change the applicable anti-dumping duty. And by doing this, they do not have to undertake a full-fledged midterm review by examining the injury as well. Apart from this, certain other changes have taken place in India. One relates to suspension of duty. Now, the Indian government has given itself the power to suspend the duty without giving any reasons for a period of 1 year. Second, another change that has come, that time period for completion of sunset reviews has been reduced. Earlier, it used to be 12 months. Now, rules specifically mention that the authority has to complete the review at least 3 months prior to the expiry of existing duties. Third change that has come about now is that the law specifically provides that in case of reviews, levy period, both in case of anti-dumping and countervailing duty, can be less than 5 years. Compared to, in comparison, the earlier provisions provided for a fixed 5-year tenure. And lastly, authority has done well based on requests from a lot of interested parties to simplify the formats as it was existing. By doing so, the biggest change that has been brought about is the doing away of the certification requirements. So now when the interested parties file their questionnaire response and give costing information, they need not be certified by an independent chartered accountant. So this will save a lot of time, effort, and energy for all the interested parties. And we feel this is a very good practice that authority has brought about. Similarly, when it comes to updating the formats, authority has also streamlined the data formats. While earlier questionnaire format asked for a number of data sheets, wherein a lot of times duplication took place, authority has now simplified it by requiring very simple and straightforward responses. Now so Sita, you have anything to add?
Yeah. At this slide itself, I would like to add a few points.
Yeah.
This anti-absorption provision comes into force. It does not yet come into force. It's an idea where the domestic industry believes or apprehends that the anti-dumping duty has not had the desired effect. The exporters are actually absorbing the duty by reducing the prices still further. Now, in order to plug this particular situation, there is no provision in the WTO law, and therefore a WTO plus provision has to be introduced. And here again, India has done something quite different from EU. If there is an apprehension that absorption of existing anti-dumping duties is taking place, India considers it as an occasion to review and redetermine both the dumping and injury margins based on a new set of data for a new period. This may be treated as partial review, but I presume it appears to envisage a similar treatment to both dumping and injury margins by recalculating not only the export price, but also the normal value and the non-injurious price. This is a notable change compared to the EU provisions. Then the last one, I would like to add one sentence. India was probably the only country that required the profit and loss accounts presented to the authority for the POI and for the product concerned for the POI should be certified by a practicing accountant or a CPA. This is creating a lot of problems in many countries where the auditor's requirements were quite different. Now, by doing away with the certification, the life has become simpler for exporters to participate. Yeah, thank you. Satish,
Right.
you can continue for the next slide.
Thanks. Thank you, Sita. Coming to practice updates. So one very unique thing has happened since 2020. So to very briefly touch upon how India does anti-dumping cases, there are two bodies. One is the recommending authority, which is called the Director General of Trade Remedies, which conducts the investigations and gives its recommendation in the form of final findings. Second is the implementing authority, which is the central government, and more specifically the Ministry of Finance, which will consider the recommendation and take a decision on implementation. So since 2020, there has been a tectonic shift in the way these recommendations are considered by the Ministry of Finance. So if you see the chart, we'll see since in 2018 and 2019, the Ministry of Finance used to accept most of the recommendations made by the authority. However, 2020 onwards, there has been a major shift when number of recommendations have been rejected. So if you see the table, we see in 2020, the rejection rates were 55% of the total positive recommendation. And in 2021 so far, till September, this number is 63%. The rejection rate is 63%. So a lot of rejections are taking place as of now in India. So if you see the chart, two trends emerge. One is that positive recommendations no longer result in anti-dumping duty or countervailing duty levy. So now, even if domestic industry goes on to show that it has suffered injury because of dumping or subsidization, the protection is not guaranteed, as Ministry of Finance may decide not to impose duties. So there is a lot of uncertainty that has come into picture since last 2 years. And this uncertainty will also remain in respect of other interested parties like exporters, importers, or users, who now will not be able to take a quick decision as to how they should make market decisions or business decisions on whether to continue business in India or not. Right. So this problem is emerging. And one more thing that has come is, while Ministry of Finance can reject the recommendations, it is not providing any reasons for rejecting such or for taking such decisions. So one can only guess what could be the reason why they are being rejected. So one theory is that these products on which anti-dumping duties are proposed, they are intermediate goods which are necessary for the survival of Indian micro, small, and medium enterprises. Another theory that is circulating is that if anti-dumping duties or countervailing duty measures are imposed, it will lead to monopoly, duopoly, or even oligopoly in some cases. And lastly, Ministry of Finance may also determine that such imposition may not be in general public interest. So these are only theories that are circulating. We do not know how and why decisions are being turned down. With this, I'll give it to Mr. Sitaraman for taking the next few slides.
Okay. There is a very peculiar issue in India. In an original investigation, if there is an exporter who got a negative dumping margin or a de minimis dumping margin, and no duties were imposed against him, but there are other exporters from the particular country on whom the duties have been imposed. In such a case, what happens in a sunset review? There are two possible views. One is that a sunset review covers the existing measure That means if there is a duty in force against a particular person or particular country, only that measure is reviewed, and whether it is extended or terminated is a decision that will take place. The second view is a sunset review covers the whole of the subject country, which means all exporters, including ones who are not subject to the existing duties. So, India has done, in some cases, covered the exporters against whom there is no duty at present, and those people have been subjected to duty at the end of the sunset review. And in one case, the authority was wavering in its decision. The domestic industry was not very happy. They initiated a review against that particular, they initiated a fresh investigation against that particular exporter for whom nil rate of duty was there. But then after initiating the investigation, the authority came to a conclusion that, look, there is no need for a fresh investigation against this one exporter. He will get automatically covered under the sunset review or any other review, because the review covers the whole of the subject country. Well, this is something very unique. I haven't come across from other locations in practice. Maybe there are one or two examples around the globe, but this is something new. But if I look at the anti-dumping agreement, the agreement article 11.2 only talks about the anti-dumping duty, existing anti-dumping duty or existing anti-dumping measures. So there is no scope for misinterpretation that it would cover the whole of the subject country. If there is no duty, there is no review. That's how it should be. I think this needs to be decided, and right now 1 or 2 cases are in Indian courts at various stages, and maybe we will get a good decision. But till then, this is something very much considered and alive in India. What should happen to a person who has not got a dumping margin in our original investigation or a review? Okay, can we go to the next one? Yeah. See, same thing in the sunset reviews. What should the authority do? Many countries, for instance, US, Canada, EU, and maybe a few more, say in a sunset review, the scope is very limited. We will either modify the duty or we will either continue the duty or terminate the duty. That's what they do. If at all they have to modify the duty, they have to introduce or conduct a midterm review or a partial interim review or a parallel review, whatever you call it. There will be a review separate from the sunset review, and then only through that parallel review, the duties will be modified. But in India, probably like in South Africa also, at the end of the sunset review, the duties can be modified. But there are a number of problems in it. Increase or decrease for one particular producer already subject to duties, or previous duty continued for all, duties reduced for all, or new rate of duty for a new entity which did not have a specific rate earlier, and unchanged for all others. You think of any combination, you can find an example in India in a live case. So what is the policy? We don't know. What is the law? It's uncertain. But the decisions are taken on a case-to-case basis based on the facts of the individual cases, but that's creating a lot of uncertainty. And there is another view, another problem that arises in sunset reviews. There is a 6 months post-POA data was being regularly considered till about a few years back. But now that 6 months post-POA data is not being considered so regularly. There are some investigations where the initiation notice of the sunset review will say the authority may consider post-POA data, but they may not consider it. But there are now investigations where it is not being considered by the authority. I think not considering the post-pivot data is a good practice, which is globally done by most countries. I would welcome if the authority continues with the current practice and says, I will not look at the post-pivot data. In any case, you are going to look at the likelihood. Whether you look at 6 months later data or 6 months earlier data doesn't make much of a difference. What we can do a likelihood analysis, but that is what is happening. Yeah. Is there anything else? Yeah. With this, I thank you very much for the opportunity. Tracy, I think we have maintained the time of 10 minutes. Thank you.
Hi, everyone. A very good morning, good afternoon, good evening to everyone across the country. I believe I'm next, right? So unless Nicolaj stops me, I'm going on. I will aim to sort of try and keep this short, sharp, because I don't want to go into each of the nitty-gritty country details at this, in a sense, late hour. Before I get on, let me say thank you to Tracy for pulling this all together, all the hard work. So thank you very much, Tracy, and Rhonda from the IPBA to try and get the whole seminar running. And of course, to my fellow panelists as well, coming in from different jurisdictions at all different times. Myself, I'm based out of Singapore. My name's Kala Anandaraja, and I'm with the firm of Raja and Tan. What I'm going to cover today, and I don't have slides, but happy to discuss this offline with anyone else who's interested. What I'm going to discuss today is touching on Southeast Asia and looking at the kind of actions initiated against Southeast Asian countries and Southeast Asian countries themselves initiating actions as well, basically anti-dumping or safeguard actions. Now, the Southeast Asian countries, who are they? Sometimes known as Asean, they essentially comprise, starting from the north, Thailand, Vietnam, Malaysia, Myanmar to the, a little over to the west, Cambodia, Laos, Philippines, Singapore, Indonesia, and Brunei. So you're looking at 10 different countries. The countries have a lot of similarities, but also quite a bit of differences. And the key differences, I think, is not all of the countries are producing countries, whether it be agriculture or raw materials, commodities, and so on. And typically, when you look at anti-dumping or safeguard type cases, they would be against countries which have strong domestic industries. So it could be agriculture related, it could be commodity related, and very often it's steel, or it could be seafood. Shrimp used to be the talk of the day vis-a-vis Thailand for the longest time, for example. So if you look at the range of countries, if I pick Singapore out, we have no commodities. We have no farming. Well, I guess we have some degree of farming now to ensure that there's sustainable food supply for Singaporeans in time to come. I mean, we still import a lot of things. And despite being a country which is 40 minutes across east to west and 35 minutes north to south, that's small. There have been anti-dumping cases initiated against Singapore as well. The cases vary. One such case involved acetone by the US against Singapore and Spain, for example. So there are different types of products. Now, the countries that face such actions most often are Thailand, Vietnam, and the Philippines, the most frequent in the Southeast Asian countries. So Thailand has seen cases against them for citric acid. They've seen cases on shrimp for the longest time. Steel continues to be one which is extremely popular in all different shapes and forms. And Malaysia is one country that sees a lot of action on that front. And just picking up on steel, for instance, it's not just Malaysia. We've also had cases against Vietnam, against the Philippines, involving steel. Indonesia comes up as well from time to time, just to close the loop on that. Now, I'm just going to share one quick example in relation to steel. There was a case initiated by the US vis-a-vis the Philippines. It was cleared and the Philippines was found not to be liable in relation to circular welded carbon quality steel pipes. So you see how specific the product nature goes into. So if you're a trade lawyer, you're really looking at product classification and making it as narrow as possible to identify where the potential issue lies. Now, I said in this particular case, the matter was the US basically dropped the action against the Philippines, not because there wasn't any sort of clear violation as such, but because the volume that the Philippines was importing from the US ended up being too small. So they just sort of, in a sense, let the case be. Let me pause here and say, why do anti-dumping or safeguard cases come up? Before I go on to a few more examples, just to show you the environment in this part of the world. Why do cases come up? So I'm going to pick a leaf of what I think Satish, not Sita, but I think Satish had said in relation to India. It's to sort of perhaps protect the micro SMEs as such. But that's what governments do. That's what policy and politics to a large extent is all about. And hence anti-dumping issues and safeguard issues come up. To give you one quick example, for instance, in relation to sugar, this involved a case vis-a-vis, if I recall correctly, Vietnam initiating again a case against Thailand. So here we're going beyond just US or Australia or India initiating cases, but within ASEAN, one country initiating against another. So we had Vietnam initiate a case against the Philippines, against Thailand, in relation to anti-dumping vis-a-vis sugar. Vietnam eventually did win the case, but allegedly 3,300 workers lost their jobs in Thailand, allegedly. And apparently 93,000 farmers were affected by the whole anti-dumping that was occurring, in Vietnam. 93,000 farmers were affected because of inefficient sugar mills being operated and so on. So the impact can be quite dire. And the anti-dumping or safeguard, depending on who's initiating it, is necessary in a sense to try and save jobs, for example, to try and protect domestic industry so that jobs are maintained, but the domestic industry also flourishes. And it could be small micro SMEs, it could be SMEs, or it could be the larger corporations. But every country requires their domestic industries to be able to grow for that purpose. Now that sort of sits, in a sense, in contrast to trade and free trade agreements, for instance, right? So if you look at it from the early days, WTO, and then bilateral free trade agreements, and increasingly a lot more regional trade agreements. The key thing about free trade agreements is really to try and increase trade by reducing restrictions, whether they be quantitative or qualitative. So one of the quantitative restrictions you want to reduce is to bring down tariffs. And in ASEAN or Southeast Asia, one of the key free trade agreements that we have is ATIGA. It's the ASEAN Trade in Goods and Services, ATIGA for short. And this is a free trade agreement that has seen tariffs on huge numbers of products drop. And in fact, between Singapore, well, Singapore vis-a-vis the world, we have no tariffs on anything apart from tobacco, alcohol, and a couple of other things, that's it. But vis-a-vis the other countries, Singapore, Malaysia, Thailand, Vietnam, and I believe it's the Philippines, not Indonesia. Basically, there are no tariffs for trade amongst these countries. So before we got to that state recently, the tariffs on sugar was brought down substantially to 5%. And that was a motivation for more sugar to be moved into Vietnam from Thailand. So you start dumping your sugar because the tariffs got brought down. And free trade agreement wants to try and do that to increase that trade flow. And yet you need a mechanism to try and protect the domestic industry. And that's where anti-dumping or safeguards kick in as well. And I wanted to sort of put that out there in terms of the key purpose, just in case we have non-trade lawyers listening in. So there is a motivation for it and why that protection is necessary. And in a sense, it goes back to what Ngong Song was talking about in his speech as well. But he was going into the type of labor that we're using. But it's very much a policy ground as well, very important. Now from there, let me sort of very quickly pick up on products. Now the kind of products, I alluded to this already, on which you can have anti-dumping or you can have safeguard actions range. You have steel, you have sugar, as I mentioned, you have acetone, which was against Singapore recently. You have citric acid, for instance. And you have, there was one case which was brought by the US, I believe it was the US, against several countries, including Vietnam and Thailand, because I'm focusing on Southeast Asia, for passenger vehicles and light trucks. So you're looking at passenger vehicles and sort of light trucks that operate within these countries. And you say, hey, you manufacture it so much cheaper, and when you send it over to my country, you're trying to put it down at a very low price. That impacts business in my country. So we need to raise it and find the right answer. And hence countervailing duties are imposed as such. So the products can range in terms of all kinds of different types of products. Now, my third very quick point is in relation to the most commonly initiated parties, or parties initiating initiators. So again, Satish very kindly pointed out that India is very often number one. And it's just amazing the number of cases that have come out in recent years. The US is another as well. And do I see a number of these cases, the speed at which cases are being initiated slowing down? The answer is no. I should mention Australia. Australia also brings a number of actions against, and maybe Tracy can add to that, against various parties. Now, if you look at the Southeast Asian countries, I did say that they do initiate actions within each other as well as third parties, but it doesn't happen as frequently. And that one reason for that could also be because of the nature of the countries and being more export oriented rather than importing in a huge way products into their country as such. Now, in terms of state of legislation, each of the 10 ASEAN countries have the relevant legislation. I do not want to bore you with the different names, but essentially they would deal with countervailing duties and anti-dumping. So they will deal with both issues and essentially safeguards as well. And sorry, just to, yeah. So in terms of the legislation and whether it's actively enforced, the short answer is yes. More often than not as a defense, but very often also as using it as a sword. What I see happening in this part of the world more is the safeguard actions rather than the anti-dumping actions. So Malaysia, for example, has in recent years brought a number of safeguard actions. So this is where the country takes to protect itself, right? Has taken up a number of safeguard actions to protect its industries. What this means is that third parties coming in from other countries will need to meet higher duties to be able to bring their products into the country, and local industry is able to continue to be able to supply into the industry. Again, sounds like restrictions on trade, but it is at the end of the day finding a balance. Let me end off. So I have several examples, but I'm just concerned about time and didn't want to get into too much details. But let me end off by giving you one more example which has happened within Asia, but which concerns a very simple product, cigarettes. Now, cigarette, and this was an action between the Philippines and Thailand. So earlier I talked about Vietnam and Thailand, but this is Philippines and Thailand. And I believe Thailand Thailand imposed higher customs duties on imported cigarettes rather than what was manufactured within Thailand. The Philippines wasn't very happy with this, and so made a complaint to the WTO. Now, when I said imposed duty, so this is not just pure customs duties, but it's your value-added tax as well. The WTO essentially looked at the case and said, you know, Thailand, you have indeed acted inconsistently with the rules subjecting imported products to enjoy the sort of same level as such. But by having the VAT for imported products being substantially in excess of domestic goods meant that you have violated the rules here. Now, when you look at that, you think about what I talked about earlier in terms of protection, and it seems to counter. So what I want to leave you with is, it is not always as straightforward. You can look at, yes, the numerics, the numbers will show that, yeah, I might be dumping, I have excessive volumes and so on. But that in itself is not going to be the final determinant, because there will be defenses, and the defenses are a combination of policy and various other factors that you will need to pull together. So in terms of anti-dumping and safeguard actions in this part of the world, whilst they are defended, I think perhaps more can be done. And it is something that we do need to pick up on and fight against the Indians and the Americans. I have Indians and Americans on the panel, so who keep saying that we are dumping into their countries. Let's see how we can pull that together as well. It is an interesting area of the law. Happy to chat further. I'm going to pass the baton on to Nicolaj now. Thank you very much, everyone.
Thanks so much, Carla. Yes, my name is Nikolaj Kuplotsky. I will try to screen share the other screen. Can you still see me? Oh, wonderful. I used to work at the European Commission and the legal service, and there I dealt with anti-dumping matters inter alia. And now I work at the Court of Justice, so I've basically switched sides. Now I'm basically judging what I used to do, but of course I'm conflicted on some cases, including one or two that I'll be talking about. But the idea is that I've now switched sides, so I think I can talk a bit more freely on some matters. I will deal with recent changes in methodology on the one side, on the anti-dumping side, and a more recent change in practice on the other side, on the anti-subsidy side. So let me start with anti-dumping. And here I will be discussing the new significant distortions methodology. And as we've already heard from the many wonderful speakers across the globe, in all jurisdictions, the idea of the anti-dumping instrument follows sort of the same theory, right? It is to counteract unfair trading practices. And I think it's a bit difficult to imagine if one is not really part of this as a bread and butter practice. But I think it's best encapsulated in this Jacob Weiner example that just after the American independence, the English manufacturers dumped their products at such low prices in the US markets as to crush, and the crush was the word that he was using. I think it's very nice and imaginary in that sense to destroy this young American industry that had just gained independence from the British. And so there you see the original idea of anti-dumping was to counteract these unfair trading practices that were essentially private enterprise decisions. I would decide to sell my product cheaper than on my home market, and therefore I should be not necessarily punished, but this difference should be accounted for. The significant distortions methodology was introduced I think it's late December 2017, and basically what it does is it turns this idea of private practice decision-making on its head, because it says, well, and in effect it admits this in between the lines. It says, well, irrespective of whether you did something wrong at selling it under, well, I'm not sure whether it's doing something wrong being competitive, but irrespective of whether you try to be anti-competitive in the European competition sense of the word abroad, the source of what we are trying to tackle here is not your private decision making. It is actually somewhat higher up the value chain, sort of the distortions that trickle down from government decision making. So it's the input costs that we are going to disregard here, irrespective of your individual decision making. So this does not just concern raw materials, but what the EU or what the Commission in particular as the investigating authority is looking at is electricity, personnel costs or labor costs, and also the general regulatory environment as such. And so because you have these distortions, you have an indirect comparative advantage, and therefore your prices are sold more cheaply, and we need to act. That's basically the theory of this whole methodology. Now let's look at an example on this, because I think this example explains how the Commission, I think it was the first investigation that applied this, how the Commission approaches this in practice. Now it's steel rolled wheels from China, and these are basically these aluminium, these steel wheels that you attach either to a car or light commercial vehicles. And I think in this particular case it was light commercial vehicles, but I might be wrong. Now, how did the Commission go about assessing all these distortions? Well, the Commission had drawn up in advance a report. It's called the China report in short speak, where it details the distortions that it alleges occur in the Chinese economy. And then it allows complainants to rely on this report to argue that within their industry there are distortions. And the Commission then uses the report itself, so it has established its own reports to rely on its own reasoning to find distortions. And the way it has done in steel rolled wheels, and what it continues to do is to essentially establish two different sets of distortions. So the first set is sort of the horizontal distortions that exist in the PRC economy. So they're saying, and there's a standard language that it includes in every investigation. And it basically says that the Chinese state is essentially intertwined with the Communist Party and engages thereby in this interventionist economic policy that seeks to pursue and achieve the political goals set by the Communist Party. And these interactions occur through industrial planning, so the 5-year report being most famous, to the control and direction of the financial system, because bankruptcy laws are applied differently, all the way to the general regulatory environment. Right. So the idea is here to establish as a first layer, there's distortion at every level. So legal, institutional, and general regulatory personnel related. And it's top down, it's transversal. So all product costs, I apologize, are essentially inherently distorted because they derive from this distorted system. And then the second layer of distortions you have is a sort of vertical layer, I'd like to say, that is distortions within a particular industry. So here we have steel and we have the automotive industry. And so the China report also contains distortions on these sort of vertical industries. And there's steel, Carla just said it, steel is sort of the favorite product. There's this joke here in Brussels that unless you know 5 different types of steel, you're not a proper anti-dumping lawyer, because galvanized, all these different types of steel that you have to learn about. so steel is really the bread and butter of the Commission, and China the best client in that regard. So once these distortions are established, the Commission then goes and says, well, I cannot trust any of the costs that have been reported in your books, even if you've cooperated to the best of your abilities. You've given me everything, but I cannot trust any of the costs because it's all distorted. So I need to replace your costs, electricity, labor, as I said before, with costs from a representative country abroad. And this representative country, according to the methodology, is usually one of a similar economic development. And Brazil has been used, Turkey has been used, South Africa has been used. I mean, but essentially the choice here is not only whether you are of a similar economic development, the choice is also very practical. Do we get all that data that we need to replace? Because in the end, it is a massive effort to replace all these different input costs. Of course, a product can be rather simple, but a product can also be incredibly complicated. So you have these different input costs that all need to be replaced, and that has caused well, a lot of work for the authority, but a lot more work for trade lawyers. Yeah, so the effect of this more generally is that you have this already very complicated field. Again, I mean, Carla said it, it's a specialist field. So a very complicated field that has become even more complicated through a methodology that in response, and this is what we were presenting to the European Parliament back in 2017, I mean, we had heard earlier the general ethos, the general idea was that the China accession protocol is due to expire at some point. Now, that's not the official position of the Commission on at least parts of it, but one had to promise to the European Parliament, to the parliamentarians who were representing the institutions, the new methodology will lead to exactly the same result vis-a-vis China as the old methodology, because, I mean, one has to sell it in a certain way. So as I said, it's become much more complicated, and as a result, it's become much more complicated and more difficult to prove as individual producer exporter that no distortions affect your product. So under the non-market economy methodology, you had these, I think, 4 factors that are laid down in the legislation, and you just had to, it was still a lot of work, but you had to provide evidence that you would satisfy these factors, and then you would be treated as basically operating in this bubble of market economic, where market economic forces would reign. Everything around you is the Wild West, right? That was the idea. But now you have the burden of proof is that you have to show that these macroeconomic factors around you do not exist, that there's no distortions top down in electricity and personnel, in regulatory and all these other aspects. And this transversal provision of evidence has become so difficult that essentially I've been told it is futile to fight this idea. So what do I think this effect has been? Well, for one, I think it has shifted the focus much more on the dumping side. So now far more important than ever to have a specialist who can calculate, who know how to find their way around the Excel sheets, which is really where the money is, the good money is spent, and where you can win a case. And adjustments become quite important. There are a couple of court cases that go down the route of very interesting ideas of how to adjust the duty rate. But then above all, I think it's become ever more important to pool one's resources, because if you're an individual producer of, let's say, tableware in Guangzhou province, where there are 10,000 producers that all produce the same product, and you are being accused of dumping because of distorted costs, you as a family enterprise will not be able to lift this evidentiary burden. And so what I think should happen far more is the involvement through a chamber of commerce. I mean, all of these exporting producers have to be part of the chamber of commerce. Activate your chamber of commerce. It is linked to MOFCOM, or I think it's MOFCOM, one of the Chinese departments of state. So you have the direct link to the Chinese government. And while the Chinese government has never intervened in these anti-dumping investigations, at least anti-subsidy different, at least you can pool your resources, and potentially the chamber can provide certain evidence that at least some aspects of your production costs are not distorted. And what is Interesting also in this regard is that I just lost a case, one of my old cases, basically arguing that the chambers of commerce cannot appear in the European courts to challenge anti-dumping regulations on behalf of their members. So our argumentation was because under the case law of the European courts, they had to operate basically like European chambers of commerce with democratic voting rights, but the chambers of commerce in China are slightly different. And so we lost that argumentation. It was weak, I admit, but so now we have this very interesting possibility to lodge direct challenges on behalf of your members. And who doesn't like a good court case? I think this is sort of the result of this. The second, the second issue I would like to deal with is transnational subsidies. So this is a development in practice that is quite recent, and I think is actually probably the most revolutionary of the recent practice developments. This concerns anti-subsidy instruments. This is not anti-dumping. We're looking at a different instrument. And as I said earlier, anti-dumping is private practice, private enterprise decision-making. And this is more an idea to tackle certain government involvement in the economy. Now, transnational subsidies are basically financial support provided by one government to companies operating in another country for them then to export products produced in that other country abroad to third countries. And why is this development special, the EU tackling transnational subsidies? Well, traditionally, the idea of anti-subsidy instruments was that you had some sort of territorial limitation, that your government as a granting authority is only in charge of its own territory. This territorial limitation is where the novelty lies here, because in the glass fiber fabrics case, the Commission was investigating production of glass fiber fabrics GFF in Egypt and in China. In Egypt and in China, and this product was produced by Egyptian companies that were Chinese-owned in an Egyptian special economic zone, and the subsidies provided in that zone were provided under Chinese law. They were provided by Chinese institutions, so state-owned banks, the Belt and Road Fund, and this state-owned assets commission, which is called the SASAC. And the subsidization here fell sort of between the two between the two categories that are usually targeted, right? The Egyptian government didn't provide the money, even though it was its companies in its territory, and the Chinese government provided the money, but it was not territorially competent. Sorry, the Chinese government didn't provide the money; its entities provided the money, but it was not territorially competent. So how do you bridge that difference between these two different scenarios? Well, the Commission, and this is the first time, at least to my knowledge, that it's used this particular way out, used Article 11 of the International Law Commission articles on state responsibility to basically say, well, we can't really attribute this conduct to Egypt because it was not providing the money, but because, and I will explain this a bit later, through the factual constellation that existed, it basically acted as if it had made these subsidies its own. And so apart from the fact that this invocation of the ILC articles on state responsibility is very novel and very exciting for public international lawyers, because the Commission also used the hook of the Vienna Convention, the way the Commission proved this was saying, well, look, there's this 2016 international agreement between Egypt and China that basically says in its wording, well, these subsidies will be provided under Chinese law and only to Chinese companies, and Egypt will accept this conduct as its own. And actually the Egyptian authorities were actively involved in promoting this sort of constellation. And the language here, I think, is quite interesting. The language in the regulation, and I haven't put it down here, but it's recital 694 of the regulation that I've put, is the Chinese preferential measures in favor of Chinese entities established in Egypt were thus identified and made its own by Egypt. And this language is quite important because this language is not language that the Commission usually uses. So it was deliberately chosen to show that Egypt had accepted this this activity as basically attributable to its own government in a certain sense. And so the big question now is how, I mean, what are the effects of this? How important is this for overseas production in special economic zones? To what extent does it impact, ordinary production in special economic zones? And I would think, and maybe this is a bit leaning myself out from the window, I would think that the impact right now is rather limited. But the emphasis has to be here on right now, because it is, in my opinion, clearly a political response to the Belt and Road Initiative. So the further you are progressing with the Belt and Road Initiative, the more of these agreements that are concluded between different countries, different countries and China, in the pursuance of sort of their local economic development, the more I think this transnational subsidies methodology will be put in or will be used. But of course, you still need a number of factors. So I don't think M&A activity, for example, or individual direct foreign investment right now is affected by this, because of course you still need a subsidy, account available subsidy, not just any subsidy, account available subsidy. You still need financial support, benefit, and specificity. Then you need to have injury to the EU as well, because the products produced there, of course, they can come here. We're not as open as Singapore, but we're a fairly open economy. At least we'd like to think so. And above all, you also need to have this agreement between this producing country and the government of China, through which the Commission can attribute these financial incentives that are not provided by the host country to that host country. So quite a few hoops to jump through. But as I said, I think this is a precedent-setting investigation for what is to come under the Belt and Road Initiative. So thank you very much for your time.
Thank you so much, Nicolaj, and thank you to everyone for such fascinating presentations. I think we were scheduled to finish, but we still have our Zoom connection and we still have people with us. So can I ask if there are any questions at all, either from the audience whom we can't see on screen, if you'd like to raise a hand or use the chat function or the Q&A function, or from any of the panelists to each other. And maybe we can just take even 10 minutes to have a few questions.
Tracy, maybe if there is no question from the audience, I mean, I want to give them priority. Maybe to Nikolai, if he can comment, if there is any update regarding the currency ruling in Europe. You know, we have been listening to the currency ruling in the US. So if they have anything similar, or there is any development of the like in the EU. Thanks.
I think the answer is quite quickly. I haven't heard anything in that regard. But of course, I mean, this is not an aspect that should necessarily be sort of put aside by now, because the Commission is being very inventive, especially right now. And I met the head of unit in charge of investigations a couple of weeks ago for coffee, and he didn't mention anything. But that doesn't mean that these things are not brewing sort of behind the scenes. But let's see. I think this would be a next step in EU practice, and that this is something we can learn from the Americans. But if you are more up to date than I am, then please let us know.
Thank you, Nikolai.
if I can sort of reverse, actually, I also have a question for you, August. Sorry. Earlier you said that in Argentina, duties are extended quite easily. And you mentioned the example of something like 25, 30 years extension of duties. So is my understanding correct that it's rather simple to prove in an what we call an expiry review, a sunset review, I think, under the American terms, to prove the existence of dumping and all of this, and also under Argentinian law?
Yes, you're right. I mean, you know, Argentina, like all the Mercosur members, have mainly Brazil and Argentina have a very protectionist policy regarding their own industry. So when you have a strong local, I mean, industry, and the government is very likely to provide support to them, so it makes it easier for them to constantly extend a definite duty. This case that I discussed earlier is the one of sanitary ware, and it is against. There are two sanitary ware cases. One against China, which is the leading case of this tacitly market economy status granted to China, and the other one is the sanitary ware against Brazil, who is a Mercosur country, but nevertheless Argentina has been extended such duty for almost, I think that is going to, we're going about 20 years now. It's crazy. and the issue is that the Brazilians, I mean the producers, they are not participating anymore in the sunset reviews. So it is easier for the authorities and the local producers, I mean, on the basis on this available principle of the available facts, they decide and they provide support to the local industry.
I was just wondering if anyone has had experience during the pandemic of what difference it's making to investigations in terms of things like verification visits. So I know that was something that I've seen where verification visits that might normally be conducted by an investigating authority haven't been conducted because of COVID restrictions. I just wondered if that's something anyone's had any experience with or thoughts about how that might be impacting investigations.
Oh, yes, I can answer it from the Indian perspective. India has not been conducting actual on-site verification visits after the onset of the pandemic. Till now, they have not started. Maybe one or two visits they have done to domestic industry units where they found there is a need to go there. But with respect to exporters, they have not yet started. But that has increased the workload of the anti-dumping practitioners and the exporters. They ask for each and every data that is given support in terms of a screenshot or something else, where if there is an on-site verification, if they would have taken only 10 documents, now they need at least 100 documents. So the requirements have become more because they don't want to miss out anything. And so that becomes a major problem. And also if you have a trial balance or profit and loss account to support the data given, and they want everything to be linked to the anti-dumping formats, which becomes very difficult because not because the companies or consultants don't want to do it. Even if I link it at my end from the anti-dumping files to the trial balance or the P&L account specific heads or the cells, the moment it is handed over to the authority, the links get broken, and then it becomes a problem because oftentimes it's an Excel problem. But even if the Excel problem is overcome, physically one has to do for each and every item. Normally people go through and they will ask for verification documents of, items which are really, significant in value. Rest of them they may leave, ignore it, but now it doesn't happen. So the verifications have become more cumbersome and more time consuming.
Hi, Tracy, this is Jeff. Can I ask a question?
Yep, sorry, I was just double checking the Q&A, but we don't have anything. So, oh, we have
good.
one. Jeff, maybe if I just go to that answer, that question.
That's fine,
quickly,
go to that
we'll
and then I'll come back, yes.
Perfect. So the question is, dear experts, do you feel increasing the protectionism features in ongoing trade probes in your countries? Sorry, so I'll say that again. Do you feel increasing the protectionism features in ongoing trade probes in your countries? So I guess that you're seeing more protectionism. Please correct me if I've got that wrong.
Hi, Tracy. Okay. Maybe if I pick this one up very quickly, I think if you go through the different panelists, the answer is going to come across slightly differently from different ones of us, because I think with some countries, certainly the policy is towards greater protectionism. If I pick up Southeast Asia, I think to a large extent, ASEAN as a bloc, we're nowhere close to the way the EU is, but there has been great strides made in trying to get everyone working together and to improve that trade. Because if you look at the population across Southeast Asia, it is a powerful one, and it can only benefit each other if we open up. And yet that opening and cross-border trade, which ATIGA has facilitated considerably, can only be truly effective if there's no sort of selfish behavior in terms of I want to get more of my exports out, so I'm going to just dump it in your jurisdiction and so on. So the balancing act there, I think it's going to be somewhat difficult. And yet, even as I say that, I think within ASEAN as a bloc vis-a-vis each other, the protectionism is sort of giving way to the recognition that working together gives us more power, so that we can do trade as a bloc with, say, the China or potentially India or other sort of bigger powers out there. Having said that, if I look at some of the other countries, yes, there's certainly that air of protectionism kicking in terms of some of the actions that may have been taken by them. I will not speak to the other countries because I think we have enough of a spread here, but just sharing the view from Southeast Asia.
Thanks very much, Carla. Does anyone else want to comment on that question before we go to Jeff?
Sensitive one.
Okay. Speaking for New Zealand, we have very few trade remedies actions, but so I'm not probably as well qualified to speak as most of you around the table. Jeff, shall we go to your question?
Sure. Just quickly, one of the and for those, my name is Jeff Snyder. I'm a lawyer in Washington, D.C. I'm not really a trade remedies lawyer, but I have watched from afar and with a lot of interest today. One of the things that I noticed a lot was the discretion the authorities are exercising in a variety of jurisdictions to adapt or create new ways of trying to address dumping subsidies. And I'm wondering about how this discretion is reined in, or is there? I'm curious about 2 points. I mean, one is in the absence of effective WTO oversight, given the frustration in the appellate body, and are governments feeling more freedom to do more without worrying about being held accountable? And separately, are domestic courts able to provide any relief? And I'm thinking mostly, Sitha, regarding some of the things you're talking about in India, with the absence of any explanation for some of the measures that the government is taking. It seems very unaccountable. It seems very unfair to not have reasoned decision making when these measures are adopted. But anyone can take that. It's just my sense of a common thread is this discretion that's being exercised, and how can it be reined in the absence of an effective WTO process?
Thanks, Jeff. Although if I'm correct in understanding, in India, it's going the other way, isn't it? That the Ministry of Finance is not imposing duties, is that right?
Yes,
Yeah.
you're right. In fact, you know, if you don't look at what India has done now, only in a holistic manner, it may give a view, it may give rise to an apprehension that probably India is more protectionist. But the recent trends where, despite a clear finding by the investigating authority, the finance ministry is not imposing the duties, that shows clearly that India is not willing to expand or can even continue the existing level of protectionism. So that is one thing, but I wouldn't say that this is the clear evidence that there will be no protectionism, but there may be other forms of protectionism than anti-dumping, but nothing has come to our light which will show. But one thing is certain, what Jeff mentioned, the WTO dispute settlement body is almost different, and that, you know, is going to be a major problem for many countries, including India, if, you know, it has to take up action against some other countries. So I would think there should be a yearly solution to the checkmate in the WTO dispute settlement body.
Just to add on that, while there is an impasse in WTO, courts in India have been proactive to keep a check on how DGTR functions or the recommending authority functions. So if you see past rulings in last couple of years, many of the rulings have decided how the laws will be amended or the practice will change. So from that context, yes, domestic courts in India are pretty proactive in keeping a check on how investigating authorities function. And regarding that unreasoned order, though nothing has come out now until now how that will be taken up, but I'm pretty sure with number of rejections that are increasing, somebody is bound to take DGTR to the court or Ministry of Finance to the court. So Sitaraman, if you have any inputs on that?
Yeah, there are 5-6 products on which the domestic industry has challenged the rejections before the tribunal, but the hearing took place last week. I don't think there is any decision on it so far, but it's a touch and go situation whether the court will interfere and say that Ministry of Finance should not have rejected. That's a big question mark, but we have to wait and see.
I am conscious of the time. I expect our audience will probably be expecting us to wrap up. So I think we probably should wrap up shortly. I guess also, I guess quickly in response to that question, I mean, I do find this so fascinating in what Carla said, that, about the balance that we have to find with trade remedies. And, sometimes when I hear people talk about just protectionism and trade remedies, it's not, how do we define protectionism? Because if we didn't have these safety valves and trade agreements that allowed domestic industries to seek some remedies, governments probably would not also get the license to actually be able to engage in trade liberalization in the first place. So it really does seem to be this very fine balancing act. And, I guess with the pandemic as well, you probably have industries who maybe in better times would have been able to, accept some dumping and maybe, adjust to it. But in the face of the pandemic, the dumping might be the last straw. And so now they have to seek remedies, so yeah, it seems like it is a very fine balancing act that governments or authorities have to try to find. Would anyone else like to add anything before we close off? I mean, it's a really fascinating discussion and I'd love to carry on, but very conscious of people's time as well, not to mention the hour here in New Zealand. No?
I think.
In that case, I'd just like to thank everyone so much for participating. To our audience, thank you so much. I don't think we've actually lost anyone. Everyone's stayed through the whole webinar, so thank you very much. If you enjoyed it, I'd really encourage you to let your colleagues know that this will be available to be watched afterwards on the IPBA website, and we'll share that. So please, yeah, do share with your colleagues. And yeah, again, thank you everyone so much, and we'll talk to you soon.
Yeah, thank you.
Thanks.
Thank you, everyone. Thank you, Tracy.
Thank you. Bye-bye.
Have a good day, everyone, or good evening.
Bye.
Yeah.
Bye-bye.
Have a good one.
Thank you all. Thank you, Tracy. Thank you,
Thank you
Jeff.
so much.
Thank you.